Well, good afternoon, ladies and gentlemen. I'm Mark Pousty, I'm head of the law school, and it gives me great pleasure to welcome you to this afternoon's lecture by our distinguished visitor, Professor Tin Bao Ching, on developing environmental law in developing China. For those of you who don't know Strathclyde Law School, it's very highly ranked in the UK. We came 7th equal in the government's last research assessment exercise in 2008. Over the past decade, we've been ranked in the top 15 law schools in the UK. There are around 100 law schools in the UK, so we're doing quite well. I'm particularly proud of our rankings in the Complete University Guide. We've been ranked 10th in the UK in 2013 and also 2014. And last year we were ranked first equal for graduate employability in the UK, along with UCL in London, which was excellent. So I'm very, very proud of the progress the school is making. We also now actually appear in the top 200 law schools in the world in the QS rankings, and we're one of only 11 disciplines at Strathclyde to get into those rankings. So that's great. Now, our successes in the law school have led the university to invest quite significantly in the school. And since 2011, we've managed to make no fewer than 10 new academic appointments, which is great. And significantly, quite a number of these have been in the environmental law field. And this has enabled the school to take forward a long-standing ambition of mine, which has been to set up an environmental law centre. Now, given we have around 5 colleagues who now have an interest in environmental law, this has been possible. So this event is actually the first official event of our new centre, which is called the Strathclyde Centre for Environmental Law and Governance. And we've also managed to attract a significant number of PhD students. We have around 5 PhD students who are studying environmental law topics at the moment. We have a number of visiting PhD students from overseas and have had some visiting scholars. And I'd like to pay tribute in particular to my new colleague, Dr. Francesco Sindaco, who is the director of our new centre, and his dynamism has been driving it forward. Sadly, being head of school doesn't give you a lot of chance to take forward your academic initiatives, but I have been trying to support and promote the centre as much as possible. Francesco has also developed an exciting new LLM programme in climate change law and policy, and this is going to launch in 2014-15. And I think in the papers that you have, there's maybe some information about that. So I'm delighted at your efforts in driving forward environmental law, and to my other colleagues in the environmental law field and our environmental law PhDs for all the work that they're putting into the centre as well. So I'm delighted at what you've achieved, and you're probably pleased I'm standing down as head of school, because I might be setting all kinds of performance targets for you for the next few years if I was remaining. But anyway, enough from me. Francesco is chairing today's lecture, and I'd now like to hand over to him to introduce our distinguished guest from Wuhan.
As Mark said, I'm Francesco Sindaco, reader in international environmental law here at the law school, and as the website shows you, I also work for the Centre for Environmental Law and Governance, of which I have the real pleasure to be the director. Now, some of the things I wanted to say, actually Mark already said, so I'll be very brief. I want to give you a snapshot of what the centre is and will be even more in the future. It already is, in my opinion, a centre of excellence. There are 12 of us amongst members of staff, PhD students, researchers, I like to call you, not students, PhD researchers, and visiting researchers from Brazil, from Spain, and from Italy, all of them in this room. And considering the size of a law school also, 12, 13 is actually quite a big number. So we aim to make a difference. We aim to collaborate with other universities, and Wuhan University is definitely one with which we want to collaborate. We're collaborating already, organizing events together. In the month of November, the Center will be organizing an event on international water law with the University of Navarra in Pamplona. This is a recent development. Another important activity will take place here in Glasgow, and that's on the 15th and the 16th of October, and it's going to be an international roundtable conference on international water cooperation and the transboundary aquifers in collaboration with the Scottish Government, with the UN, and with other very prominent organizations. You do have some information in what has been given to you. Vibrant research community, exciting PGT teaching programs. Mark has already told you all about that, so I won't spend more time on that. And I will move immediately to introduce our distinguished guest lecturer. Now, Jianbao has done a lot of things, so I won't tell all of them. I have highlighted not the most important ones, but those that I wanted to transmit to you. And I do apologize if I'll read from your bio note.
No.
Professor of Law at Wuhan University. He's a part-time at the law school, part-time professor of the European Studies Center and the China Institute of Boundary and Ocean Studies, an incredibly interesting institute. He's a legislative expert for China's Ministry of Environmental Protection, an advisor of Chinese delegations to negotiations on both biodiversity and climate change related matters. He's also the Secretary General of the Chinese Society of Environmental and Resources Law. I was talking to him about it yesterday. It's a very interesting society. He's also a member of the Committee on the Legal Principles Relating to Climate Change of the ILA, that's the International Law Association. And in the past and currently, he has traveled a lot, I would say. He has been in many, many prominent and excellent research institutes and universities. And just a few of those: University of Göttingen, where he currently is as a senior research fellow. He has been at the Woodrow Wilson International Center for Scholars, Ghent University, University of Manchester, Frankfurt, just to name a few. As areas that he's interested, he's currently concentrating his work on laws and policies about climate change, energy, biotechnology, biodiversity, water, ocean, air, and water pollution, transboundary environmental issues. A complete environmental lawyer, if I may say. Now, this is just like a third of what he has done, so I didn't want to spend too much time on it, but it really gives me a great pleasure to have you here at Strathclyde, at the law school, and have you as the first official activity of the center. So I give you the floor, and I'm really looking forward to your exciting lecture.
So, good afternoon, everyone. It's really a great honor for me to come here to have this opportunity to share my understanding with the development of Chinese environmental law. Firstly, I want to express my sincere thanks to Professor Mark Posty and Professor Francisco Sindico. I'm so excited and a little bit nervous to be the first speaker for the wonderful Strathclyde Center for Environmental Law and Governance. I hope my presentation will be not so bad in this field. So I believe everybody is very interested in China and the Chinese environmental protection, so including the environmental law. Since about 1942, China has already beginning of environmental law. So my presentation today will include the four parts about the why we have the environmental law and what is the pictures of the environmental law and how the environmental law works in the daily life, and lastly what's the future trend. What is the future trend of the environmental law in China? It's very easily to understand that China needs an environmental law because of the serious environmental problems, I believe, and you get more information from the newspapers and the TV and other media. So from this picture you can find the problems of pollution and ecological destructions in the whole China. It seems that we have no clean areas anymore in this piece of planet of the Earth. So this is a typical air pollution situation in China, especially in the cities. As Beijing, Shanghai, and Guangdong. Yeah, this is a not so good picture in 2008. This is a water pollution, and this is the waste, or sometimes as hazardous waste. Besides of the pollution, we have also serious distractions, the ecological distractions, such as the deforestation, logging, and we have the sand stores. It's very famous, not so good reputation, but very famous. Yes, we have the problem of the loss of biological diversity. So it's, we have many endangered species. There's we also lack of water, especially fresh water resources in many cities. So this is a city I come from, it's Wuhan. You can, from the map you can find, we have plenty of rivers and lakes, but actually sometimes we have this situation. So the environmental problems also bring about the health risks to the general public. So there are many cases related to the health and the environment, and also many protests. But fortunately, the central government has paid much attention to the environmental problems since 40 years ago, and we have many new measures and policies to try to control the problems. So we have the ambitious plan to control the environmental situation. But among the measures to control the environmental problems, law is of course a big or most important instrument. But I have to say that China is, at least currently, we are not a country with rule of law or under rule of law. So in many cases, the policy plays an important role in daily life or in environmental protection. So I will give you two stories about the development of environmental law. So I mean, the general speaking, environmental law and the environmental policy. And it's difficult for me, actually, to distinct law and policy sometimes. So everybody knows that China is under the rule of the Communist Party, and objectively, we can say China's Communist Party is not a revolutionary party anymore. So it's, if you look back to 30 or 40 years ago, you find that China's like the picture left. But now China's Communist Party is more like a green party, especially it has a green charter to guide the activities of the party. So since the beginning of the 1970s, China has issued many policy documents and held several national conferences on environmental protection to express its view to solve the environmental problems. So you can find since 1981 we have several decisions from the State Council, that is central government, on environmental protection. And China released this Agenda 21 in 1994, which was the first national Agenda 21 at the global level after 1992's the Agenda 21 in Rio de Janeiro. And China hosts the National Conference on Environmental Protection almost every 5 years to to establish the new policies or to set out the new direction of the environmental protection for the future 5 years. So this is the general information about the past conference, a national conference on environmental protection. But besides the policy, China paid more and more attention to the rule of law in the economic development and the social progress. So since 1972 to currently, China's environmental law has a rapid development. I will show you a little bit more information. So as I'm not so sure maybe everybody knows the Cultural Revolution year, and at that time the philosophy of the central government is very I have to say bad. It has many slogans such as the great steel making and moving the mountain to create farmlands, reclaiming land from lakes. So the core idea of the philosophy is that impossible is nothing. The people can conquer the nature. So there are some pictures show the situation at that time. To some extent, thanks to the UN Conference on Human Environment in 1972, to which China sent a delegation. So during the conference, the delegation realized that China faced with serious environmental situation, similar to other countries, especially the industrialized countries. So it's a big shock for the Chinese leadership at that time. So afterwards, the Chinese government began to issue some environmental standards or regulations in this field. So they just several years after the United Nations Conference on Human Environment, China issued its third constitution. So fortunately, environmental protection was introduced into the constitution, which was the first time in China's history, especially the history of legal development. So since that time, the environmental protection became the main task, one of the main tasks of the government. And it also set out the realm of the environmental law for the future's development. And 1 year after the constitution, China has its first national environmental law. We call it the environmental law for trial in 1979. 1982 is an important year for China or for Chinese people, because this year we had the new constitution, which is also the existing constitution. So there are several articles set out the tasks of the state to protect the environment, especially Article 26 and Article 9. So this is the China's environmental law entered into a rapid progress time. We have plenty of environmental laws enacted during that time in field of pollution control and in field of natural resources conservation. About 10 years after the first national environmental law, China revised it based on the new situation and based on the international successful experience. So the 1989 environmental protection law is the existing, we can say it's basic environmental law in China. So that is the with the 1989 environmental law as a core, China established preliminarily the environmental legal system. (1999) is another important year for China, and in this year, Chinese Communist Party and the new government introduced a new idea of rule of law, and one of the goals of the state is to establish a country under the rule of law. So this, with this incentives, China began to amend its environmental law according to the requirement of rule of law, and they also enact some new laws. For example, the environmental impact assessment law, or cleaner production promotion law, or renewable energy law, something like that. So we can say, coming to the 21st century, China's environmental legislation has gone into a new stage. So its basic nature is to lead a society with respect to the nature, to seek harmony between the human beings and the nature. Actually, this is a ancient idea of Chinese people. So from the quick introduction of the development, both in law and policy, we can find that at the beginning 10 years, the policy seems more important than the law in environmental protection. But since 1990s, law played a more and more crucial role in protecting the environment in China. But that does not mean policy is not important anymore, you know. So how environmental law works in practice? So I will give you some information about the legislation, legal framework, and the administrative structure, and even the principles and the regimes. So this is the hierarchy of legal system of China, and normally we have the constitution as the top, and the NPC is National People's Congress, is a Chinese parliament. So it's a legislative organ in China who issued the laws, and the State Council is central government, which issued the regulations. And the ministries can issue its own rules, but at the provincial level, sometimes we have local rules and local decrees. So for the environmental law system in China, we have the articles of the constitutional law for the protect the environment, and we have the environmental protection law, and we have the pollution prevention and control law, natural resources law, and ecological conservation law. So it's a kind of system. So you will find that we can say that China has already an independent environmental law system, and the environmental law has become an independent legal department in China's legal system. But the system actually is not so perfect. We have several problems. For example, the many laws at the national level, the articles or provisions sometimes are outdated, and the articles or provisions among different laws, some of the conflicts are overlapping. So that's bring about bigger problems for the implementation and enforcement. So one of the main tasks for the Chinese government for the legal framework of environmental protection is to improve the quality of environmental legislation, to avoid the shortcomings and deficiencies, and to try to introduce the integrated pollution control, integrated ecosystem management, and other new advanced ideas into the new laws. And China still needs a comprehensive environmental law, a true basic environmental law, because the 1989 environmental protection law is quasi basic environmental law. It's not really a basic environmental law, and the law is focused mainly on the pollution control. It has few visions involved the nature conservation and other topics. As to the administrative structure, this is the basic system of the power in China. So you can find the legislative power is always at the top, and the administrative power and the judicial power is below than the legislative power. So that is different from the situation in the European countries and America. So this is the administrative structures for the environmental protection in China. At the national level, we have a state council. Under the state council, we have the Ministry of Environmental Protection. But this ministry is not the only competent authorities for protecting the environment, because we have several other ministries. For example, Ministry of Water Resources, Ministry of Forest, Ministry of Land Resources. So the environmental, the MEP, Ministry of Environmental Protection, is the main competent authority, but not the solo one. Then we have a similar structures at the provincial level, municipal level, and the township level. So Chinese government try to reduce the scale of the government, to reduce the number of the personnel of the government in the past 20 or 30 years. So it has several governmental organization reforms. But each time, the nature of the environmental department was not reduced or not how to say affected. Actually, each time the environmental department was upgraded or strengthened. You can find from this slide that since 1974 to 2008, the role and the level of the environmental department get more and more important support from the central government. Since 2008, the environmental department became the Ministry of Environmental Protection in China. That's a significant progress in the terms of administrative structure. So it's luckily now the ministry, the Department of the Environment entered into the center of the decision making at the national level. But as I mentioned, the MEP is not the only one. We have several other relevant ministries and commissions and departments. So there's different kind of mission creep or competition or back passion, right power or authority competition among the different departments and ministries. As to the principles and the legal regimes, we have also some progress. For example, the fundamental principles, the idea of a sustainable development has entered into the daily life of China and become the guiding philosophy in protecting the environment and developing environmental law. And we have several other important concepts, such as the precautionary principle, polluter pays principle, and the public participation has been introduced or transformed into China's environmental law. But problem is that China changed the guiding philosophy too often. Thank you. Because the guiding philosophy always changes with the shift of the focus of a central government, or not central government, or the party. So that actually affect the stability and the authority of law, especially the environmental law, because you change it or you revise the law each time when the party have a new slogan. So we always said that China's law is like the moon, So it's at the beginning of the month and in the middle of the month seems different. China's legal regimes for the protection of the environment also get also some progress. We have EIA system, which is from the United States. We have a so-called the three simultaneous. That means any new constructions, if you want to build a new construction, the design, the design and the construction and the operation of the construction must have the environmental facilities at the same time. So it is the three stages. So that means three simultaneous. We have the pollution charge. So if you want to emit the pollutants, you must pay the fees to the government. Now we also have the pollutant license, centralized pollution control, and some other regimes. In last 10 years, we paid much attention to the economic incentives, not only the command and control measures. So, for example, the environmental tax and charge and the integrated ecosystem, clean production and payment for the environmental service became new systems or new regimes of environmental law. But in line with the Chinese philosophy for legislation, China always said we should not enact a very detailed law because the society and the situation changes frequently. We cannot revise our law every time, so the law normally should be general. So that's a big problem for the implementation and enforcement. If you have no clear and exact legal ground for the administration, how can they enforce the law? So, for example, this the environmental impact assessment, the law encourages the public participation, but we don't know how the public to participate in the process of the assessment. So what's the future for China's environmental law in the context of the the booming development, especially the economic development in the near future. Personally, I have 4 points about the trends of development of environmental laws. First is scientific and economic incentives. Second is public participation. Third is a new sign of environmental law, is environmental courts. Lastly is about the internationalization of environmental law. China's environmental law undergoes a shift of outlook on the rule of law and science and technology. At the very beginning, the Chinese people regard the environmental problems just a problem of science and technology. They don't think it's a comprehensive problem. But later they say, oh, it's a social problem, we should use law. But they seems not so paid less attention to the rule of science and technology. But recently, how to use the advanced technology and how to combine the law and the technology is a new emphasis of China's environmental law. And the economic incentives, as I mentioned just now, is more and more important in our daily life. For example, the Chinese government introduced the so-called plastic bags ban, the ban on the plastic bag. That means if you go to the supermarket will not provide the plastic bag free of charge anymore. You must pay for the plastic bag. So it's a very useful incentive for many general public, because you must pay more money if you want more plastic bags. Actually, it's very funny. As before the ban, if you go to the supermarket to buy, for example, a bottle of water, then you buy, for example, the bread or toothbrush, maybe they will give you 3 bags because it belongs to different category of production. So that's very, you can say this is a kind of attractive factor of the supermarket, but it's not really not so good for the environment. So it's more and more people will bring their own shopping bags to the supermarket. This is only one example of how the economic incentives plays a role in the daily life. We have many other economic incentives. Secondly is the public participation. So the development of environmental law in China basically mainly is based on the top-down approach. As I mentioned at the very beginning, that China's environmental law starts with the impact of UN Conference on Human Environment. The central government realized the importance of environmental protection, and they want to try to educate the general public the importance of the environmental protection. So normally the central government said, oh, how important is of the situation, so we should do something for that. But recently, especially in the coastal area of China, eastern part of China, the development of environmental protection or environmental law is kind of bottoming up. The new generation, the so-called middle class people, has its own interest in cleaner air or cleaner water. So they want a better environment. So they want to push the government to do something. So now it's a mixture approaches. Now this is the rule of the public participation. Follow the structure of the Aarhus Convention. We can divide the rights of the public participation into 3 types: so access to information, participant in decision making, and access to justice. frankly speaking, we have a good foundations for the first two types of rights, the access to information and participate in the decision making, but not so good in access to justice. So this is some pictures for showing that how the general public to express their ideas or their against for the proposed environmental non-environmental friendly projects. The first two pictures are pictures showing the protest in Xiamen. Professor was will go there. In 2007, I think there was a proposed PX project. It's kind of a chemistry plan of there. The plan was very close to the communities of the citizens. So the people were very angry over there, and so they said we should do something to stop the project. That is difficult to apply for a lawful protest in China. So the people said we can go to the street together, and we work together, to show our ideas. So this is the story. Now this is not the only case. We have several situations like that since 2007, because the citizens of Xiamen finally succeed. So they pushed the government to transfer the plant to another place. So here and some other protests during the past few years. So there was a tension between the public and the government who want to develop the economy. This is one case about the request for information, open information case. Because we have two important regulations. One is the disclosure of governmental information. Another is made for the disclosure of environmental information. So based on these two regulations, the citizen, the general public, are entitled to request relevant information on environmental situation. As to the public participation, the Ministry of Environmental Protection issued the interim measures on public participation in environmental impact assessment, who provided the firms channels, ways of the general public to take part in the process of the assessment. But for the access to justice, it's not so easy in China, even till now. So we have a new science of environment development. It's very interesting that we have a specialized environmental court. China is mainly a civil law system country. So we have only an ordinary court. And the environmental case normally we divide into three categories: civil case, administrative case, or criminal case. But this kind of environmental cause is a new type of one, and the court can accept all kinds of environmental cases, no matter it's criminal, or civil, or administrative one. So it's very useful. We have already several successful cases in the Guiyang and some other cities' environmental courts. So lastly is about the internalization of the environmental law. both law and environmental law actually were borrowed actually from outside of China, because we have no legal tradition. So we studied the law from other countries, especially from the continental Europe. But at the very beginning of China's, the development of China's environmental law, we learned a lot from the United States. Partly because of the environmental law in the US was very good, partly because of the language problem. But I have to say that recently, China shifted the focus on EU environmental law. And we think there are several reasons, the political reasons or other. From the legal perspective, I think it's, the EU law are more similar to Chinese law. And another reason is that I don't want to criticize the attitude of the United States, but somehow they are not so active in international environmental protection, especially in biological diversity or climate change. So China feels easier to learn something from the EU or EU's member states. So that's the possible trace of development in China, according to my own observation. So my conclusion about the development of environmental law is that environmental law has already adopted more priority position in the whole legal system, with the implementation of a sustainable development strategy and the construction of the so-called green society. And the philosophy of the environmental law will continue to be updated, such as a new concept, ecological civilization. Actually, this was raised by the party. Or environmental democracy or integrated decision making. So the China's environmental law, of course, are not so perfect, but I believe we are in the right direction. So that's all my presentation today. So thank you very much.